Distinguished members of the bench, Somane. For the record, I do appear with Dr. William Tubwa, Mr. Hassan Nura, for the Iebc. Dr. William Tubwa and Mr. Hassan Nura. We are the 16th respondent. We are not with the other respondents. We are the Iebc. We are on our own and to clarify matters to the court. Distinguished members of the bench, just for the record,
we hope that you are not sharing the minutes. These 5 minutes.
The Lordship it's just me. We are not sharing.
Right.
We decided we will not distribute the time. I will try to cover as much ground as I can in the time allocated. If I need 1 or 2 minutes, I will be kind enough to, but I will try to cover. I know it's very late. Just for the record, we rely on the replying affidavit sworn on the 25th of October 2024 by Hussein Marjan Hussein, who is the CEO of the Commission. We rely on the written submissions dated 27th of October 2024 in response to the various petitions and the applications. We rely also on the written submissions dated 27th October 2024 with regard to the application for conservatory orders, as well as the bundles of the authorities. They are on record, the Lordship, and we have filed and served the same. The Lordship, on preliminary issue, today, good I came last because it was a learning experience for me, but also for preliminary issues. To the extent that a lot of the petitioners and even some aspect of the respondent dwelt on merit review of the petition. When this is an application for conservatory orders, those submissions should be disregarded by the court. That's the first one. The second aspect, even though the decision for the petitioners is an application for their rights in personam, the fact that the Iebc is here and this is a public interest matter, your decision will be a decision in rem. So the Iebc will be asking that you clarify for it the applicable principle and guide it on first principles. The third one, and which is very important, is it seems that there's a general agreement that the law that will apply, and this is the only thing that all the lawyers agreed on, is Munya. Itagatirao Munya is the standard for conservatory orders. We believe the court should adopt that standard. I will not dwell much on the prima facie case, but I will dwell a little bit on the negatory aspect as it relates to my client. My client has been bundled up into these proceedings to establish the application for conservatory orders on 2 grounds. And this is important for the court to note this, on 2 grounds. The first one, the petitioner said that the Iebc has a constitutional role in filling a vacancy in the office of Deputy President under Article 149 of the Constitution. And this is important. The second aspect, they say that even though they have a role, they cannot discharge that role because they do not have the constitutional and legal capacity to function, as they don't have commissioners. This is very interesting. This is what my professor at Harvard Law will call constitutional chaos. So they tell you there is a role to be played by the constitutional body. And then they say, once you establish there's a role to be played by the Iebc cannot play that role. The Lordship, in Itagatirao Munya, and this is a point that has not been made by most of the council, the issue of conservatory orders is not for the benefit of the private or the public party. Conservatory orders is for the benefit of the court. because they are supposed to preserve a judicatory capacity of the court. Just that. If a party benefits because of that, that is collateral. And that is really important for this court. Because once you establish it for your adjudicatory capacity, two things fall away. The first thing that will fall away, if you find that there is a remedy, there is an alternative remedy in merit review when the petition is heard, there are remedies that subsist when the petition is heard, then that aspect falls away. The second aspect that will fall away, if you make a finding that there's a constitutional mandamus, and Your Lordship, I will refer to you to Article 145(7) of the Constitution. If you make a finding that there's a constitutional mandamus, injunction, edict, direction to the court, then you have to stop there. And Article 145(7) is in such mandatory terms that there is no other way that this court can interpret. X, the president shall cease to hold office. Constitutional injunction, mandamus. So if those two findings are made, then there is no way the petitioners can establish the negatory aspect. As relates to the two issues, the gravamen of dispute, the position of the Iebc is that the Iebc does not play any role as it relates to vacancy through impeachment under Articles 99 and 137 of the Constitution. There is no constitutional role for the Iebc. There is no statutory role for the Iebc, and I'll come to that because we spent quite a bit of time. Just like the predicament the court is in, whether it should intervene under 165, we also had that predicament. Is there a role for the Iebc? That is the question the CEO of the Iebc asked. And we came to the very considered conclusion, there is no role for us because of constitutional design. And I'll come to that constitutional design. Unlike the court, the Iebc has been involved in a lot of litigation against itself. And there is directions from the Supreme Court of the Republic on what Iebc can do and what Iebc cannot do. I want to refer the court to paragraph 13 of our submissions, the BBI case, the Supreme Court one. And Iebc here can be substituted also for this court, because this court is a creature of Chapter 10 of the Constitution. The Iebc is a creature of Chapter 15 of the Constitution. And this is what the Supreme Court says. At paragraph 13 of our, we've quoted it verbatim. Number one, the Supreme Court says, the Iebc, being a creature of Constitution and statute, could only discharge mandate vested in it explicitly by law. This court, being a creature of the Constitution and statute, can only discharge mandate vested in it explicitly by the law and the Constitution. The second one, which is very important for this court, is the court said that this was direction given under Article 10(2) of the Constitution and the aspects of rule of law under Article 10(2). The third point that the court made, the Iebc, like other public bodies, could not by craft of innovation, and this is really important, Supreme Court. The Iebc, like other public bodies, could not by craft of innovation or interpretation extend its powers. So it is sufficient for the Iebc or even for this court to look at the Constitution, not the Constitution, and the statutory law, and not get and exercise what is within the inner boundaries of that. And D, which is to this court, courts should not encourage extension of powers by constitutional or statutory bodies. And this is really important, paragraph 13 of our submissions, Your Lordship. So the constitution of my client Iebc is under Article 88(1), 253, and 259. The position of the IEBC relating to this matter is that Article 149, 145, 150 establish a complete self-contained code. It is a constitutional codified mechanism. It's not a statutory mechanism for governors or members of National Assembly. It is a constitutional codified mechanism. So when this court is interpreting, IEBC is a creature of the Constitution. This process is a creature of the Constitution. You cannot get out of the Constitution for this process. This court is a creature of the Constitution. So as it relates to the nomination by the President, as it relates to the parliamentary vote, it is not envisaged there is an involvement of the IEBC. This is a constitutional mandamus. As against the IEBC, and I will say as against even this court, we also rely on the case of Engineer Geoffrey Sang versus the DPP and 20 others, your brother Justice Odunga, paragraph 18 of our submissions. And he says that the law is very clear that powers must be expressly conferred. They cannot be a matter of implication. You cannot imply powers. And this is the absurdity. If this court was to make a finding, for example, that IEBC has a role, the way IEBC conducts elections is known, or by-elections. So the second order question we'll be asking the court is, do we declare a by-election? Election by its nature is a contest. How will that contest of filling that office be had? Do we bring ballot papers? Those are the secondary order questions that the absurdity of the finding of the court that IEBC has a role will entail. The second thing, our position, is that this constitution is very detailed. It is very interesting. This constitution tells you how it should be interpreted. And Article 10. It tells you under Article 201 how the principles of taxation that will apply. It has what we call constitutional carve-outs, the powers given to various entities. It will be high presupposition to assume that this constitution under 149 could have said that this process, it says for even members of National Assembly. It says for members of National Assembly, and even in the elections that we have that. For an office that is that high, there is, to say that the Constitution could not have said that IEBC has a role or this court has a role would be a very grand supposition. The Lordship, we looked at, so we asked the question, what the court should ask. If someone said IEBC has a role, we looked at the things that we will look at. So we'll say, what did the framers think? Can we look at constitutional history to say if there was a role for the IEBC? The IEBC looked at the Bomas draft, Article 168. It looked at the WACO draft, Article 159.1, and we looked at the Harmonious draft. And in all of them, there is no role for the IEBC. So even by constitutional history and constitutional design, there was no role for the IEBC. In fact, there was a role in the WACO draft for the Supreme Court, and those submissions have been made by Mr. Mugomi Yankulu.
Thank you.
Your Lordship, just 1 minute, I'm almost winding up. Your Lordship, for you to, and then there's a second issue, and then the reason why the court should not interfere in this process, especially I would find there's a role for IEBC. For you to make a finding, for you that the first finding that you have to make, there is first, the people who hold public office, they hold what we call rhetoric relationship. These are relationships of trust and confidence within our constitutional architecture. Relationship of trust and confidence within our constitutional architecture. So you have to make a finding first. There is a property in public office, okay, number one. And that confidence is to the Constitution, number one. You have to make a finding. There is a property to hold in public office, okay? Even when there is a breach of that trust. And a finding has been made by other organs of the Constitution. And the court, the test has always been threefold. Number one, total interference, judicial fear. And we don't do that, our courts don't do that. Courts don't substitute their preferences to what other organs do. The second aspect has been total deference, not to what other organs do, but total deference to the Constitution. And this is very funny. Professor Gideon Muigai is here. I used to teach first year contract, and the case of Feldhouse versus Kindiki came to mind, that the Constitution is silent, so that means that we can read into things, or we can tell the court to intervene. The Constitution is silent on the court intervention under 149, so we read into it. So that's the second aspect. Total deference, if there is a constitutional injunction, constitutional mandamus against a public body or against this court, then the court should be able to deal with that. The third one is the intermediate test. And this is what the court has applied, Your Lordship. The intermediate test is you do procedural constitutional compliance. This is our authorities in E181, Justice Majanja's judgment in the Finance Bill Act. In fact, the decision of the Finance Bill Act Supreme Court came down a few hours ago. I think we provide to the court should look at it. The threshold for public participation is not PAT, by the way. The threshold for public participation is even lower because of that decision. And when you look at that decision, which we provided to the court does what we call procedural constitutional compliance. And what is that? You look at whether a vote happened and the threshold within the Constitution have been made. No more than that. And that is supported even by the decision of the Supreme Court, which came down just a few minutes ago. And I want to read a small excerpt, Your Lordship, on that decision, which we have provided to the court.
Which one are you talking about?
I'm talking of it is Your Lordship, just the citation is E031 of 2024, consolidated with E032, E033 of 2024. Came down just a few hours ago. And I will just refer the court.
How is it reported?
It is reported as E031. Let me just again. It's not reported, but it is petition number E031 of 2024, Cabinet Secretary for National Treasury versus Okia Omtata.
Petition number
E031 of 2024, as consolidated with petition number E032, E033 of 2024, Okia Omtata, the Cabinet Secretary for National Treasury versus Okia Omtata. I argue that matter. I was led by Professor Gideon Muigai. Mr. Ochiel Dadi is there, he can rebut, but he was part of those proceedings. So the threshold is even lower for public participation, number one. That is something that the court has to look at. But importantly, what did the court say about interference at paragraph 208? And I will end here, Your Lordship. Paragraph 208, the Supreme Court of the Republic it quoted the case of International Trade Administration Commission versus in South Africa, and this is what it said. I'll just read a small excerpt. Where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. I think that is good law for you. It is a direction to you. And if you look at that case, if you look at Peter Munya, if you look at the nugatory aspect, and if you look at the fact that there is at what the submissions of Marjan Hussein Marjan and our submissions, you will find there is an express constitutional injunction against interference, not only for this court, even against Iebc. Because if you told me this is an election you are able to clear, then I'll tell you, how am I supposed to conduct this nomination process? And what are the constitutional orders flowing from that? Your Lordship, our submissions are sufficient. I am being told to step down, but thank you so much.
Who has told you?
Oh. No, I was being told by Professor Giri.
Professors of this faith, my lord.
My professor is telling me to step down, but if I can, just
No,
a second.
it's okay, you can step down.
Not me, but Professor, but our submissions are, those ones, they are on record, and even if there is a role to be played by Iebc, our position is those are administrative roles which we will still play, but, and that is provided for under Section 11 of the Iebc Act, Section 13(1) of the Iebc Act. The role that we have to do under 137 is to check the voters register, and we check voters register for even people who, for Kenyans every other day. It's a public document. There is no role for the Iebc to play, and if the court was supposed to think there was a role for us, then we say those are administrative roles, but the court should not find a role for us.
This supply authority, you have quoted E031 to E033 of 2024.
I will, it is hot off the press, I will submit it just now.
Submit to our assistance.
I will, Your Lordship. I will, thank you so much for this.
My Lord, I want to apologize if I am here to take judicial discretion from you. It was intended to keep my promise to you that we would be brief.
We now get to know that every side has a prefect. This time, the prefect is Professor Giri.
My lord, just want to also add my voice to the submissions now made by the respondents. It should go on record that my name is Richard, the Solicitor General for the Attorney General, together with Professor Vicky Mugai and Charles Mutinda and the rest of the team. Yes, my Lord, to say one or two things so that we wrap up submissions from our end. My Lord, it is not any contestation that under Article 145(7) of the Constitution, a final decision of impeachment was made. It is not in doubt, and that has not been controverted by either side.
No, we have. That is what we are challenging.
A final order, at least, my Lord, was made. Secondly, my Lord, it is also not in contestation that a vacancy has arisen or arose in the office of the Deputy President. It's also, my Lord, not in contestation or in doubt that Article 149 of the Constitution was invoked in terms of the President nominating Professor Abraham Kithure Kindiki as a nominee to that position, and that Parliament voted on the same. And I would agree with my learned colleague who has just left the floor, Mahat, that the framers of this Constitution never intended that the Iebc plays a role when it comes to the issue of impeachment. And my Lord, if they so intended, nothing could have stopped them from expressly stating that position. And therefore, my Lord, I am submitting the interim orders that were granted and are in place cannot cure that position. And therefore, my Lord, relying on the various authorities that have been cited, and more particularly, my Lord, the Munya case, which is a classic case in terms of what will be required in the grant of conservatory orders. It is my humble submission, my Lord, that that has not been met. I also submit, my Lord, that when you look at the greater public interest, my Lord, we want to persuade you with the very many other arguments that have been given by my learned colleagues, that you will find favor that the discharge, the vacating, or the burying the orders that have been in place would find greater good than holding those orders in place. And therefore, my Lord, to conclude, I will urge my lady and my lords to find that we cannot continue holding the country at ransom. We need to make a decision that some of the roles and the responsibilities that are played by the Deputy President, which are currently at a standstill, would be extremely good and critical, that the moment these orders are vacated, the rest of the processes should be allowed to be completed. I therefore humbly submit that you discharge the orders that are in place and allow the entire process to be completed. I submit, my Lord.
Thank you.
My Lord, I want to confirm on behalf of the respondents that we rest that with your kind indulgence, if there is to be a reply, I think again we need to remind ourselves that it ought to be on points of law. If the case is rehashed afresh, we will still be here tomorrow, and it will be contrary to procedure.
My Lord, I also request a direction on whether persons who are not parties to the application, because there are only 2 applicants, have a right of reply, because my understanding is that the only persons with the right of reply are the parties who filed the application, not the entire coterie of this side.
Thank you, Dr.
Well, the 2 things.
Why are we being preempted?
So, 2 things on the way forward. I think we still have to hear interested parties. All of we have done. Anybody? We finished with yes. Now the right to rejoinder is only limited to the applicant and not any other person supporting the process. So it will go only